Everyone, and welcome to this video tutorial in which we're going to be doing some exam preparation for OCR A-level law, and this video is looking at the exam format of the OCR Lawmaking and the Law of Tort exam paper. I've switched my screens here so that you can see that I'm now looking at the OCR A-level law, lawmaking and law of tort paper, and you can see that this is the sample question paper that's provided by OCR to help students to prepare for this exam. So this particular exam, you'd be allowed 2 hours to answer it, and you need to answer a total of 5 questions. In section A, you're going to answer 1 question out of a choice of 1 and 2, and 1 question from a choice of 3 and 4. And section B, you're going to choose part 1 or part 2 and answer the 3 questions below. And you can see here that the total mark for this paper is out of 80. So let's scroll down and have a look at the different exam questions, because that sounds a little confusing, but it makes much more sense when you actually look at the paper. So if we scroll down then, and I'm going to start by looking at section A on lawmaking. Section A, you need to answer 1 8-marker and 1 12-marker. So you're going to choose either questions 1 or 2 and either question 3 or 4 on this paper. Question 1 and 2 you can see are worth 8 marks, and they are the explain or the describe type questions. Questions 3 and 4 are worth 12 marks because they're a more challenging question, asking you to discuss advantages and disadvantages, or in other words, to evaluate a particular area of the legal system. Choose either question 1 or 2, whichever you think you can get the most marks on. So the extrinsic aids to statutory interpretation, you'd be talking about things like dictionaries, Hansard, Law Commission reports, relevant case law, relevant acts of parliament, any international legal instruments, or potentially the Interpretation Act of 1978, all those extrinsic things that help a judge to interpret an act of parliament. Alternatively, if you choose question 2 here, you need to describe the stages of the parliamentary lawmaking process. And I do have a video on my channel that's dedicated to answering this question in detail. You just need to look at the parliamentary lawmaking process. But just briefly here, you would need to include the pre-legislative process, green paper, white paper, and outline the different stages that a bill goes through before it becomes an act of parliament. So first reading, second reading, committee stage, report stage, third reading, then go into the other house and getting the royal assent. And then you're going to choose either question 3 or 4. Again, you need to look at which you think you can get the most marks on. Question 3, again, I've got model answers that go through the advantages and disadvantages of the literal rule in detail, which you can take a look at. But in brief, you'd be talking about advantages including things like clarity and predictability, forces Parliament to be more clear in their language when they're actually making an act of Parliament. It's respecting sovereignty and respecting separation of powers. But of course, we do know that on the downside, it can lead to absurd and unjust results. And you could talk about cases like Berryman there, and cases like those undermine Parliament's intentions, and it assumes an unattainable perfection from draftsmanship as well. Alternatively, you may prefer to discuss the advantages and disadvantages of creating law using Act of Parliament. In this question, you'd need to be talking about the fact that that is the alternative to creating law through common law. And of course, advantages of parliamentary lawmaking are that it's democratic and it's being made by elected representatives. There's a consultation stage. It goes through lots of stages through both houses of Parliament. But of course, disadvantages, you could talk about things such as Parliament not having the time to deal with all the reforms that are proposed, and that the legislative process has many stages. It can take a long time. and little time's given to private member bills. Acts of Parliament can be very long and complex. You could talk about old-fashioned language in, for example, the Offences Against the Person Act 1861, and talk about how, even if we make an Act of Parliament, it will become outdated, and language can't cover every possible eventuality which may come up, and therefore you're likely to get judge-made law or common law coming into play anyway. So that's section A. Let's scroll down to section B then, and this is where we get into the law of tort. And you are told that you need to choose either part 1 or part 2. So part 1, you've got a couple of scenarios here and 3 questions. And if I scroll down quickly to part 2, again, you can see you've got 2 little scenarios and 3 questions below. So it's the same format. Both section B are on the law of tort, but you're going to need to scan read part 1 and part 2 quite quickly to decide whether you want to do this one or the other alternative question. In our first scenario in part 1, we've got a classic negligence situation here where we've got 2 characters, Ahmed and Bilal, and there's an incident involving a powerful petrol lawnmower that has a warning on it that everyone should be wearing goggles, and Ahmed is showing off with it, doesn't warn his neighbour that his neighbour should be wearing goggles, and Bilal is injured. And you're being asked to advise whether Bilal will be successful in a claim of negligence against Ahmed. To answer that question well, you would need to apply the 3 elements of negligence: duty of care, breach of duty, and damage. And so to start off with on duty, you'd be talking about the Caparo test and that it's reasonably foreseeable, this event that's occurred. There is proximity between your characters in the physical sense, and in terms of Ahmed's awareness of the potential risk, it's going to be fair, just and reasonable to impose a duty because he's not a public body acting in an emergency. You could say that he's breached it by falling below the standard of the reasonable gardener, and this is evidenced by the fact that he's actually showing off and doing something which he shouldn't be doing, going too fast. In terms of causation, it's reasonably foreseeable harm, but for Ahmed's actions, Bilal would not have suffered his injuries. There's no intervening acts, so it looks as though that's met, and therefore it looks as though Ahmed might have to pay damages to Bilal. In saying that, though, you could also talk about whether Bilal's damages should be reduced because of his own contributory negligence, and also potentially was he volenti if he has a similar mower and therefore knows what the risks are. So once you've answered that question on the first scenario, you then need to look at this second little bit of scenario, and we're going to need to advise Bilal again, but this time on occupier's liability. Quick scan of this little scenario shows it's a classic sort of occupier's scenario where Bilal has gone to stay in a hotel. He starts off, it looks like, as a lawful visitor, but then in the night he goes to use the swimming pool despite there being a sign saying that he shouldn't be doing that. He goes in anyway, he's injured. So you'd need to be applying the law on the Occupiers Liability Acts 1957 and 1984 here. I have some videos on my channel which go through in detail precisely how to apply occupier's liability to a scenario, but just briefly here, you'd be talking about the fact that Lush Breaks Hotel seemed to be an occupier for the purposes of the Act, and to begin with, Bilal's a paying guest and therefore he has a licence to be on the premises. However, when he reads this sign, ignores it and goes in anyway, he becomes a trespasser under the 1984 Act. Lush Breaks will owe the duty of common humanity under the 84 Act if the 3 aspects of section 1.3 are satisfied. Firstly, it seems that there is an obvious danger when a pool is empty and in darkness. Lush brakes could anticipate trespassers being in the vicinity of the danger if the door's left unlocked. And 3, lush brakes could easily have offered some protection by locking the door. But you would need to consider the status of the warning notice under section 1.5, and under this section, the warning must be sufficient to enable the trespasser to be safe, Rolls and Nathan, and it would seem that lush brakes look likely to be liable under section 1.3 as they satisfy the 3 aspects, but the warning notice acts as a full defence since it was capable of making Bilal safe, and you could talk about the case of Tomlinson and Congleton there. The final question on this part is an essay question, and you'll notice that the essay question on this section of the exam isn't related to the scenarios, it's just an evaluative question, and here you're being asked to discuss the extent to which vicarious liability is fair on employers. And I won't go through a suggested answer here because I have got a separate video that goes through a model answer to that on my channel. Just have a look in the vicarious liability playlist. So that was part 1. Your alternative, if you didn't fancy the look of that, you could have gone with part 2. And again, part 2, it's the same structure. You would be answering the 2 little scenarios and the essay question. Notice that the essay question is the same one as on part 1. So you can't escape that essay question. And again, you can look at my vicarious liability videos on that. Look at our options here on part 2. The first scenario, advise Andy and Becky on private nuisance. And this is your sort of classic scenario where Andy owns a house opposite a place that's using noisy equipment, and it's keeping him up at night. He's being affected by factory lights, delivery lorries, and the daughter can't get a mobile phone signal. So you'd need to apply the law on private nuisance there. And you talk about the fact that Andy's an occupier as he has a proprietary interest in the land, Hunter and Canary Wharf. Since there's no physical damage, the claim will be based on interference with comfort and enjoyment of the land, and this involves establishing unreasonable use of the land. And you could use St Helens Smelting Co. and Tipping, or Sturgis and Bridgman there. And the interference is indirect and continuous, despite only starting recently, Crown River Cruises. And the case has similarity to Halsey and Esso, you could talk about that. And Andy would need to check that super screens don't have planning permission or any sort of statutory authority. In terms of Becky, the daughter, because she's only age 15 and she has no interest in the property, she's unable to bring a claim, but that doesn't stop Andy bringing an action if his signal is similarly affected. And this problem is similar to the facts of Canary Wharf, and you could talk about that case there. The question involves a Rylands and Fletcher scenario where some oil has been brought onto Newton's recycling land, and the oil escapes and causes some mischief. And you need to apply the law on Rylands and Fletcher here. Talk about the fact that storage of the oil in such industrial quantities is likely to be considered as a non-natural use of the land, since Transco and the requirement of exceptional danger is fulfilled. And although there's a public benefit derived from this recycling facility, the activity may be seen as bringing with it a potential level of danger to merit it as a non-natural use, which overrides any public benefit. And you would need to talk about the damage to Clarissa's greenhouse and also the potential defences to this claim as well. To the greenhouse is the kind of damage which can be claimed for. It's reasonably foreseeable type of loss. There are some arguments on both sides relating to this type of escape, and you could talk about Stannard and Gore on escaping smoke from a fire. And you could also discuss whether Newton Recycling may claim an act of God, and discuss whether the weather conditions are going to be sufficiently extreme for that. So I hope this video has been helpful in just showing you the exam format for OCR, Law of Tort and Lawmaking.